Hello, friends. If you are collecting Social Security, disability, or SSI right now, or if someone in your household is, there is a letter the Social Security Administration sends that most recipients have never prepared for. It names a dollar amount, sometimes a few $100s, sometimes several thousand, and it tells you the agency intends to recover that money from your benefits. Here is the part that confuses almost everyone who receives it. Even when the overpayment resulted from the Social Security Administration's own calculation error, not yours, federal law still allows the agency to pursue recovery. That feels deeply unfair, and it is genuinely counterintuitive. But the law here separates two questions that most people treat as one. The first is whether you owe the money. The second is whether you have a legal right to have that debt forgiven entirely. Those are two different legal questions, and most recipients only ever get told about the first one. Today, we are going through both and 4 other protections the law gives you so that if that letter ever arrives, you know exactly what to do before the withholding starts. Quick context before we go further. This video is made for anyone in the United States currently receiving Social Security retirement benefits, disability benefits, or supplemental security income, or anyone with a family member who is. The goal is to walk through 5 specific legal protections that exist when the Social Security Administration sends an overpayment notice, so you understand what options are available before a situation becomes urgent. Everything shared here comes from publicly available official information, the Social Security Administration's own guidelines, federal law, and specifically the Social Security Act itself, and findings from the Social Security Administration's own Office of Inspector General. I will name each source as we go. This is educational content only. It is not personalized legal or financial advice. And nothing here is a promise that your specific debt will be waived or forgiven. Everyone's situation is different. And before any major decision, talk to a benefits counselor or attorney who knows your circumstances. Now, 5 protections. One of them can erase the entire debt. Protection number 5 is the one that prevents the letter from arriving at all. The Social Security Administration requires you to report certain life changes within 10 days after the end of the month in which they occur. Not eventually, not when it is convenient. Within 10 days after that month closes, the list is longer than most people realize. Marriage or divorce, a new address, any new income, and this includes cash work, freelance projects, selling items online, rideshare driving, or seasonal work. If you receive SSI and move into a family member's home where they cover your rent or groceries, that arrangement counts as income and must be reported. Travel outside the United States for more than 30 consecutive days. A new pension from a job that did not pay into Social Security. The death of anyone receiving benefits on your account. Pause here and write that list down. When the Social Security Administration calculates an overpayment, one of the first things they determine is whether you reported the relevant change on time. If you did not report and they discover the gap later, they calculate the overpayment back to the month the change happened and recover the full amount under current withholding rules. If there are changes you have not yet reported, report them today through your online My Social Security account or in writing to your local office. Keep a record every time you report. A written confirmation, a screenshot, the date and method. Documentation of timely reporting is your most valuable protection if a dispute ever arises. Now we skip ahead for a specific reason, and we will come back to fill the gap. Protection number 3 is what you do if the most powerful protection coming shortly does not go through. It is called an installment agreement. An installment agreement is a written request to repay a smaller amount each month over a longer period, rather than having a large percentage withheld from your check all at once. It requires a written request to the Social Security Administration, along with documentation of your monthly income and your monthly expenses, showing why the standard recovery amount creates genuine financial hardship. When preparing that documentation, the standard that matters is whether repaying the full withheld amount each month leaves you without enough to cover housing, utilities, food, and medication. Those categories, basic necessities, are the core of what the Social Security Administration considers when reviewing a hardship claim. The agency is not legally obligated to agree to any specific monthly amount, but they are required to consider your request. And outcomes people have documented include monthly repayment amounts as low as $20 to $30 based on demonstrated hardship. Put it in writing and provide the financial documentation. A verbal request over the phone carries no legal weight. Protection number 1 applies when you believe the overpayment amount itself is calculated incorrectly. You have the right to appeal the determination to ask the Social Security Administration to review its own math. This is called a request for reconsideration, and it must be filed in writing within 60 days of the date on the overpayment notice. If you believe the dollar amount is wrong, if you believe the dates are wrong, if you believe the agency is counting income that does not apply to your situation, file that written request before the 60-day window closes. The appeal and the waiver request are separate filings. You can submit both at the same time. You do not have to choose. The Social Security Administration's own Office of Inspector General has documented in their annual reports that a significant portion of overpayment cases result from the agency's own administrative errors, not recipient fraud, not deception. For many people receiving this letter, the number on it may not be correct, and the situation that created it was not their fault. That matters enormously for the protection we are about to cover. Before we get to the last two protections, consider a situation that shows exactly why the order of these actions matters. This is an illustrative composite based on a pattern that appears repeatedly in benefits counseling cases. A 71-year-old retired postal worker in Pennsylvania, we will call her Margaret, received a notice saying she had been overpaid $8,200. The Social Security Administration had recalculated her benefit after discovering she had worked a part-time job for 4 months 2 years earlier. Margaret called the agency. She was told she owed the money. She believed she had no choice. She did not know she could request a waiver. She did not know there was a specific form for it. She did not know that federal law required the Social Security Administration to consider forgiving the debt entirely because the overpayment was not her fault. And repaying it created significant financial hardship. For 14 months, $600 was withheld from her monthly check. Then a family member found the right form online and filed it on her behalf. The waiver was approved. The $8,200 was forgiven. But the 14 months of withheld payments before the filing, that money was gone. The filing could have happened on day 1. Protection number 4 is specifically for people receiving disability benefits, SSDI or SSI. When you receive a continuing disability review notice, the Social Security Administration is asking for updated medical documentation showing that your condition has not improved enough for you to return to work. If you do not respond, or if your documentation is insufficient, your benefits can be terminated. But here is the protection most people miss. If your disability benefits are terminated after a review, and you file an appeal within 10 business days of the date on the termination notice, your payments continue at the same level while the appeal is processed. Pause and write this down. 10 business days from the termination notice date. That is the exact window. Miss it and payments stop immediately, potentially for months, while you wait for a hearing before an administrative law judge. This is called continuation of benefits pending appeal. And it exists because Congress recognized that cutting off a disabled person's income during a lengthy appeals process can be catastrophic. One important note, if the appeal is ultimately denied, the Social Security Administration may ask you to repay the benefits received during that continuation period. That is a real risk, which is why building strong documentation before any review notice arrives, consistent treatment records, documented symptoms. Regular visits with your doctors is the most effective long-term protection available. Gaps in treatment can be interpreted as evidence of improvement, even when your actual condition has not changed. Now we reach protection number 2. This is the answer to the question this video opened with. Federal law, specifically Section 204B of the Social Security Act, separates the repayment obligation from the waiver, right? Yes. The Social Security Administration can legally require repayment of an overpayment regardless of who caused the error. That is the answer to the first legal question. But that same law contains a second provision that is completely separate from the first. It says that if the overpayment was not your fault, and if repaying it would defeat the purpose of the program or be against equity and good conscience, which in practice means it would cause genuine financial hardship. The Social Security Administration is legally required to consider waiving the debt entirely, not reducing it, waiving it, forgiving it completely. When both conditions apply, the agency cannot simply decline to process your request. They must evaluate it. And when both conditions are genuinely met, the standard outcome under the Social Security Administration's own guidelines is full forgiveness. Write this down. The form is called Form SSA 632BK. It is the official waiver request form from the Social Security Administration. It is free and publicly available. Filing it is the action that opens this legal process. The two conditions are, the overpayment was not your fault, and repaying it would cause you financial hardship. Both must apply. Include documentation of your monthly income and monthly expenses when you submit. The critical rule is this: file before withholding starts. Once the agency begins taking money from your check, your leverage drops significantly. The moment an overpayment letter arrives, before you call anyone, before you do anything else, submit a written waiver request. Even a simple letter stating that you are requesting a waiver under the Social Security Act, that you believe the overpayment was not your fault, and that repayment would create financial hardship. That letter submitted in writing with a copy kept for your records establishes your position before the clock runs. Here are the 5 protections together. Protection 5. Report life changes within 10 days after the end of the month. That is the prevention tool. Protection 4. If disability benefits are terminated after a review, file your appeal within 10 business days to keep payments coming while you fight. Protection 3. If the waiver is denied, request an installment agreement in writing with documentation of income and expenses. Protection 1. If the amount is wrong, file a written request for reconsideration within 60 days. Protection 2. File Form SSA 632BK the moment the letter arrives, before withholding starts, citing both conditions under federal law, the Social Security Act. That is the one that can erase the entire debt. 3 things before you close this video. First, log into your online My Social Security account and review your current benefit record and earnings history. The Social Security Administration maintains that account, and it is where official notices appear. Second, if you have received an overpayment notice or are facing a disability review, talk to a benefits counselor or an attorney who works in this area before the deadlines in that letter pass. Many legal aid organizations offer these consultations at low or no cost. The decisions made in the first 30 days after a letter arrives determine what options remain available to you. Third, if someone in your life is on Social Security or disability right now, a parent, a sibling, a neighbor, send them this video before something happens. Not because it will, because the day a letter arrives is not the day to be learning this for the first time. If your situation involves disability benefits specifically, and you want to understand what triggers a review and how to build the documentation that protects you before any notice arrives, that is the next video. It is linked right there.